thanks a lot for the introduction. Let's get started. Why don't we start with a brief introduction about yourself or what your company, your project is doing? Maybe starting from Adam over here.
Arigato gozaimasu. Adam Miller from MIDAO, which stands for Marshall Islands DAO. So I've written the laws in the Marshall Islands, which is a country in the South Pacific, creating the world's best legal entity for DAOs and Web3. It's a DAO LLC, comes in nonprofit and for-profit options, and I'm a big believer in the use of legal entities to help protect DAO members and contributors.
My name is Nicolas. I'm one of the co-initiators of Q Protocol. We provide a governance framework for Web3. Q Protocol is a DAO. We have received regulatory clearance in Germany and Liechtenstein about 2 years ago, and are providing treasury protection and external governance oversight.
Hello, everybody. I'm Anthony, CEO of Aragon. Aragon launched the first DAO framework in 2017, 2018. Which is helping to secure the assets and protocols of many DAOs around the space, including Lido, Decentraland, Curve, and most recently Polygon announced that they would be governing on Aragon as well. So yeah, really happy to be here and have a great chat.
Thank you, Anthony. I'll just give a very brief self-intro as well. Hi, everybody. My name is Jim. I'm working at Borderless.company, which is a project by a Japanese startup called Overlay, and we're trying to build a platform enabling, well, at first, Japanese groups to launch legally compliant DAOs using the legislation that went into effect in April, but eventually bridging to international other jurisdictions as well. And if we have time, I'll explain a bit about the Japanese law. But anyway, to get started, we just had a nice, lively backstage discussion. I'll try to highlight some of the best moments to share with the group. I think maybe not everybody's familiar with the jurisdictions, the different jurisdictions that can support legal entity for DAOs, and also maybe why you even need, or when you need a legal entity for DAOs. So I was thinking maybe we could start first with a brief discussion on, the when and why do you need a legal wrapper? When do you need a legal wrapper? Or maybe what are maybe some of the pitfalls of having a legal wrapper? And I know maybe some of the opinions differ with the different members, but I think it would be helpful for the audience to understand some of these insights. So maybe we could start with Adam over here.
Yeah, so in almost the entire world, when a group of people engages in a collective activity, they are given a default legal treatment by their governments. And that legal treatment is that you can be held personally liable for whatever goes wrong with that organization or project, right? And that means that if you have 50 people in a Discord server working on a project and you get sued, or the government comes after you and decides that your DAO owes $50 million in a fine for breaking a rule, they will literally come after you personally for your money, your assets, your home. Right? And so that's the biggest reason that people need to consider using legal entities for their DAOs, is that they provide you with a liability shield. In the traditional startup world, we all know that one of the first things you do when you start a company is you create a legal entity for it for that reason. Now, beyond that, it also comes with tax optimization so that you're not necessarily personally liable for taxes. It allows you to do things like open a bank account for your DAO if you want to interact with Web2 and TradFi, sign contracts. So like if you want to sponsor an event and need to sign a contract, you need a legal entity to sign a contract. So all these benefits that you get for traditional organizations, you also get using a legal entity for a DAO.
Thank you, Adam. Maybe, Nicolas, you could explain from your perspective.
Sure. So I am a little more critical of legal wrappers for DAOs. And the reason being mainly because my idea of a DAO is that in a world where we have an economy that is digital, that is decentralized, that is independent of nation states, where you have people from all across the world work in one project, I think a DAO is a form of organization that we need to establish and try to understand what it will be for that world that is independent of nation states. Also, if you think about legal wrappers, you will always just catch like one jurisdiction. So your DAO might, like the Q protocol, we have people working in Q in 6 continents. So if we had a legal wrapper in Liechtenstein, where the foundation is, you know, it's like we would put people all across the world under the laws of Liechtenstein. And I don't think that's the idea. I'm not totally opposed against legal wrappers because I look at the world of like everything's a tool, you know, a DAO form of organization is a tool to achieve certain kinds of organizing people and work. If you do need a legal wrapper because otherwise you couldn't pay people on the ground or like whatever, then it's fine. But I would always advise to be really nuanced. And what we do with Q is, one of the things we do is we provide like a very basic legal framework for your DAO where you can start organizing the internal workings of your DAO and also liabilities of members of the DAO. And I think that's a good starting point, and everything else is then depending on what you actually need and want to achieve.
Yeah, so you were saying before that you can kind of preset these definitions of responsibilities and all this stuff at an early stage without in preparation for maybe if you want to do a legal wrapper later. You were saying,
yeah. So for me, a legal wrapper must serve a specific purpose, because as a starting point, I wouldn't see why you would need one. You know, because there are other ways of. I mean, we've seen it in other circumstances, international trade, maritime law, like all kinds of specific areas where you reside into private law and private arbitration, for example, for dispute resolution and whatnot. And that is a sort of a legal framework. And it's even acknowledged by most nation states that way. But you don't need legal wrapper in whatever country for that matter.
So yeah, I just wanted to make the point that, there's a lot of different kinds of DAOs. Maybe adding a legal wrapper might, detract from the decentralized or autonomous, properties of DAOs. And so it is important to think about when and why you need a legal wrapper, not just assume like, oh, it's just, something we definitely have to do. And there are a lot of differing opinions on that. Anthony, anything you'd like to add?
Yeah, absolutely. This is one of the hottest topics, you could say, when it comes to DAO creation, is in general the lack of clarity around legal wrappers or the legal aspect of having a DAO. Obviously, it's a tool, which Nicolas mentioned, which I think is really important for people to understand. And we have hundreds of DAOs, you could say, per month coming in, and this is often a question that they have. It's like it's a fear. It's like they have a huge fear around how they're going to set up their DAO. Do they need a legal wrapper for the DAO itself? Do they not? What kind of legal wrapper? Where? And the reality is that a lot of these projects end up being captured into a lot of bureaucracy very early on in their life by sort of having the wrong legal wrapper, going down the wrong legal route, getting the wrong information. And it's really important that they do their due diligence and that they work with their lawyers and they work with their team to decide what they're trying to achieve. What are you trying to achieve as a DAO? And then, obviously, working within those parameters. I mean, we have so many unanswered questions every day. And some people believe that the DAO shouldn't have a legal wrapper. Some people do believe that they should. Some advise that their DAO members legally wrap themselves instead of the DAO. And there's so many of these questions. And I think the most important thing is to be honest also with yourself as a project. What stage are you at? Do you need to launch a token at this point? Do you need to launch a fully on-chain DAO at this point? And then what do you need to do that safely for you and your community members and to achieve your goals is super important. And so it's everybody wants the silver bullet. Do I need a legal wrapper? Where should the legal wrapper be? And sadly, the answer to that question is it really depends on your situation.
Great, yeah, and I hope that some people found some insight in that. So that kind of leads me into the next question. Let's assume you do need a legal wrapper. I'd like to ask the panel, if they any insight they'd like to provide on, different what they think is a favorable legal jurisdiction or a non-favorable favorable legal jurisdiction. Since Adam here is, promoting Marshall Islands, maybe we could start with that.
Yeah, so the reason we created the new DAO LLC in the Marshall Islands is because about 2.5 years ago, we were looking for a legal wrapper for our DAO, and we looked at literally every available option in the world: Switzerland, Cayman Islands, BVI, Delaware, et cetera. And at the time, every legal wrapper in the world required you to have a board, required you to know the names and addresses of all of your members, and had other requirements that to us was not compatible with our vision for our DAO. And so that's why we reached out to the government of the Marshall Islands, which was a leader in the shipping jurisdiction industry already, and said, hey, we want to create a legal wrapper that's made for DAOs and made for Web3. And so with this Marshall Islands legal wrapper, you don't have to have a board or managers of any kind if you don't want to. You don't have to know the names and addresses of your members as long as you have their wallet address tracked by a token or some other smart contract. All of your record keeping and accounting can be done on-chain, so there's no need for paper-based record keeping and accounting. There's other benefits too. We still see, like, the majority of crypto projects still, I'd say not the majority, but the most popular jurisdictions are probably the Cayman Islands, often combined with BVI. Switzerland, Delaware is still really popular. If you're a project that's based in one country, like a Japanese-focused project, or a German-focused project, you probably want to use a Japanese or a German entity. But if you're global and you are looking at the range of available options, still a lot of people are going with Cayman Islands because it's been used in crypto for so long. Lawyers are comfortable with it. If you can afford the sometimes $100,000 or $200,000 price tag, that's fine. But again, that's why we created the Marshall Islands option. And Japan actually followed suit in April, passing a DAO law so that Japanese projects do have an LLC option available here. But those are the reasons we like the Marshall Islands. If those particular things are important to you, that were the reasons we created the legal entity there.
Thanks. Yeah, I know. From my perspective, it's hard to keep track of the latest movements in all these different jurisdictions. Personally, I didn't know before about the Marshall Islands, but it sounds quite favorable. Nicolas, I know you were saying that the Q protocol could be used to make frameworks that aren't necessarily tied to a specific jurisdiction, but could later be applied to many different ones. Maybe you could elaborate a bit on that for the audience.
Yeah, so the service we provide, or the idea is that the DAO organizes on the basis of what we would call a constitution. The DAO could call it whatever they want to call it. And it would be a private contract between all members of the DAO. And in that private contract, you would not only state like the purpose of the DAO, decision making, most importantly, how to change those rules. It's like that is very, very important to be able to progress through time and then maybe towards greater decentralization. And then an integration with the ICC Court of Arbitration, which does the following. A, it provides a means for dispute resolution for disputes within the DAO. And it's not the only option we have, but what that specific option does is, whenever there is a dispute within the DAO, you have a framework, you have a transparent framework, and you can go to the ICC to have a dispute resoluted. And because the ICC is being acknowledged by pretty much all relevant jurisdictions in the world, what would happen if somebody sued a member of the DAO, the judge would look at the Articles of Association or the contract or the Constitution, whatever you might call it, and say like, wait a minute, you guys have opted into private arbitration. We acknowledge this very private arbitration, so go beef it out before the ICC, and then you can come back for enforcement on the ground. This is a principle that's been around for ages and had been developed out of international trade. And that forms a very basic beginning of an organization. And then at later stages, depending on what you want to do and what you need, you can always add to that. And even the legal wrapper can be added to that. But you have a good starting point.
And you guys actually integrate that ICC decision into the base layer of the chain, right?
Yes.
Yeah. I think that's what's very unique about Q.
Yeah.
And you could do that in an early stage, then later on add the legal. You kind of set up these understandings at an early stage in the DAO formation, and even before you're ready to add the legal wrapper later. It gets you in a better position to legalize yourself later.
Yes, it's tooling. You know, like all of this is just tooling. It should be used to, like, when needed, for what it is needed, and there are different ways of doing that. This is one way we set up our own DAO, and we can provide others with the same abilities. And it actually worked. So, like, I mean, some of you might have heard of the infamous UkiDAO case. And that was the problem. The problem was not that the United States, like the California court, I think it was, that the judge wanted the DAO to be a partnership, and that judge didn't have a choice, you know. A judge needs to tap into the toolbox that is provided to them. And had they had such a private contract with an integration with the ICC, that judge would have had an option to say, like, nope, go beef it out with the ICC, don't come see me, you can come back for enforcement, because that's what the idea is.
Yeah, I love that both of you are dogfooding, obviously, you know, your DAOs, your protocols, what you're working on with, you know, distinct legal wrappers. I think that's one of the best ways for us to solve these issues and determine what is a great methodology and set precedent to move forward. I can give some, like, generalistic trends of what our DAOs typically use and see, and it really spans across the globe to some degree. Switzerland definitely has one of the more long-standing and most widely used legal wrappers from a nonprofit foundation association perspective. I would say it's definitely at, like, the higher level of respect in the industry. Really large projects typically like to use the Swiss system. It's a bit slower moving. It's actually not terribly expensive, but you need money. Then Cayman Islands is also, like, probably the most adopted right now, and definitely seeing a lot of DAOs, medium-sized and larger, using Cayman Islands. It's quite flexible from my understanding, can be quite expensive, but it's very favorable from a tax perspective as well, which is probably why most of them are there. You know, Marshall Islands I'm starting to hear about as well. Actually, a project we're working with is using them, and really liked that you could sort of match some of the on-chain components to the legal wrapper itself. And then most recently, Austria, Germany are some other ones I'm hearing about. And now it's great that Tokyo, from my understanding, they've been speaking with Switzerland, are starting to work on something as well. I think the most important thing is that we need clarity from all of these jurisdictions on what, you know, and we need more jurisdictions to provide that clarity. So, for example, the reason Switzerland is so popular is because you have that clarity. You have stability. You know exactly what you're going to get, what rules you can play by. If you play within those rules, you're going to be fine, right? And so that clarity allows organizations to begin their DAOification process and do that more efficiently, make probably less mistakes out of fear. And so I think that's, like, the crucial point. So it's great that two projects we have here are diving deeper into not quite as widely known legal wrappers, so that we can start to get those out there, have more DAOs work with them, and learn and iterate and be more confident and comfortable if a DAO decides to use them.
Thanks for that. Anthony, I think you also were mentioning some pitfalls to, you know, some legal things to avoid, or other downsides to legalizing too soon. I don't know if there's anything insights you want to share with the audience.
Yeah, one of the largest pitfalls, I think, in the industry is projects decentralizing improperly too quickly. That means launching a token potentially without product market fit, launching a token when they're not ready, sort of putting legal things aside, how they're going to build their DAO aside, put those on the back burner, launch their token, begin this process, and not really have an understanding of where they're headed. And then often they get caught up in this, in pretty intense bureaucracy. And let's be honest, most projects in Web3 are startups. And the last thing you need to succeed as a startup, that you will fail for sure, is way too much complexity and bureaucracy when you're searching for product market fit. And we see a lot of projects do that and then quickly fall into this trap. And I can tell you, as somebody who's, like, you know, working directly with lawyers, accountants, et cetera, on a daily basis for a large organization, it is extremely time consuming extremely energy intensive when you should be focusing on your users and your product. So biggest pitfall, in my opinion, in our entire industry is that.
Thanks. You want to add something, Nicolas?
So I could not agree more, especially with the idea of decentralizing too early, having the token too early. And there is like this fear that, or I hear about this a lot, that people say like, but I need an organization, I need all of these things early on, and I need to be decentralized in order to get around like regulation or whatever. And I just wanted to share, like for us, we received regulatory clearance 2 years ago, as I said, and we were not fully decentralized. We still are not fully decentralized. We still received clearance because what regulators are looking for, and this is not legal advice, this is just my personal experience, and I've worked in telecoms and other regulated areas. What they're looking for is mainly two things: transparency and decentralization, or like, can somebody run with the money? Is there a person or a small group of people who can compromise whatever business protocol you're doing and can run with the money? That's what they're looking for. If you provide them with a transparent framework, or like a way to go and go more decentralized over time, and you're not pretending to be something you're not. I think that's the worst you can do, you know, to pretend to be very decentralized and then have one guy with an admin key do everything. That is the worst you can do. So rather tell everyone what you're doing and then have a very clear path and very transparent path towards decentralization whenever that is required and benefits you. Because decentralization is hard as well. You know, it's not an easy thing to do.
I mean, I agree with not decentralizing too soon or launching a token too soon, but would you guys agree that by the time you're launching a token, that's probably the time that you should have legal advice, some kind of, whether it's a legal entity or some kind of legal approach, and you should be decentralized? Because the way securities laws work in most of the world, which are the laws that I think most often get in people's way when they're trying to do a token and not get sued, those are the laws that require you to be decentralized in a sense. I mean, it's done by really restricting you from having a centralized group of people that you're relying on. And so what we often see is that by the time someone's ready to launch a token, they need to decentralize before they launch it, or at least before they sell it, and really give control over the protocol, over the organization, to as large a group of people as possible with as little management as possible, and then launch the token so that then you don't look like there's a centralized group of people. Well, I shouldn't say look like, so that you don't have a centralized group of people that a regulator could come after and say, people relying on you for the success of that token, therefore it's a security, therefore you're in trouble.
Yeah, I think there's a great distinction there, which is super interesting. A lot of projects start where they launch their token and they start using off-chain voting, for example, and they sort of put on this display that they're decentralized, but then there's this, you know, multi-sig in the back that just does everything. The reality of that is that it's not decentralized at all. The courts are not going to probably look at that as being decentralized at all. So I think the very honest thing that needs to be said there is that you are getting signals from your community to make decisions, and that it's non-binding. Whether or not you're a DAO at that point is another question or argument we can go into, of course. But yeah, that's super important to note. And I think the problem is projects are launching tokens really early, often way too early. They want to try and capture, they think this is going to help them generate or have a larger treasury, generate more users by having a token. The reality is that I do personally believe that you really want to have a pretty strong signals of product market fit before you launch your token. And if you do that, you probably can go and be decentralized upon token launch much more quickly. And you should definitely go speak and get legal advice before you launch your token, no question, and then make your decisions after you do all your research. But I think that distinction is really, really important. If you're using off-chain voting and you have a multi-sig in the background, you are not decentralized. That multi-sig is centralized and is what will take on 100% of that risk. and you need to be very careful of that. And I think that's a big pitfall of DAOs. And my preference would actually be probably that they continue to try and get product market fit, because most are protocol DAOs or product-related DAOs. Not all, but most. And for those ones, get product market fit first. If you're not getting product market fit without a token, you're not going to get it with a token. So really important to note.
Yeah. Maybe adding to that, like two quick things. One, out of our experience, the very last question both regulators asked us before we received regulatory clearance was, do you have any admin keys or multisigs in your system, in your protocol? How do you do code upgrades? And only after we could show them how we do these things without any admin keys, we've received regulatory clearance. So that speaks exactly to what you said. You do have admin keys, you are centralized. Absolutely. The second thing is a word of caution. And again, not legal advice, but in the jurisdictions I was trained as a lawyer, it does not matter whether you are decentralized or not. If you're selling a security or what's deemed to be a security, securities law apply. So be very careful, because there is this idea in the space that by forming a DAO, you can get out of securities law regulation. And to my understanding, this is not true, or at least not necessarily true. Because even if the token would not be considered a security, if you advertise it as a security or something that is like a security, then regulation will hit you for advertising it. So I think that's what you meant with like a silver bullet. Be very careful with these silver bullet ideas. More often than not, they're not true. There are no silver bullets in these kind of things.
I mean, to me, it's one of the factors, and I most commonly look at U.S. securities laws where there's like 4 factors, and being decentralized helps you avoid one of those factors. To the point about multi-sig, so I want to share a thought on that point, because if you look at, for example, DAObase.ai, which is one of my favorite tools for looking at statistics about DAOs, like 95% of the 200,000 DAOs out there, because I agree we could debate whether they're really DAOs or not, it's an interesting conversation for another time, they're all on Snapshot. They're doing off-chain cryptographic voting combined with a multi-sig. Now, one cool thing you can do is you can use a legal wrapper or any legal form, or I think Q in some novel ways, to actually enforce that those multi-sig signers must act in accordance with the outcome of the votes. And so in that case, it creates a different set of considerations where maybe those people are really not in charge, because they're just kind of utility players that have to do what the DAO wishes. And so now I think you can have something that it's a bit more like a DAO and a little bit less risk of having a multi-sig combined with something like a snapshot.
Wow, yeah, no, those were some amazing insights. Thank you all for sharing. I guess we have about a minute left, and I would feel a bit remiss if I didn't at least plug a bit the Japan law that came into effect in April. And basically, I have a blog post about this, which I'll share in the chat room for this event. But Japan has been having some nice progressive legislation recently, such as passing a 6-month digital nomad working visa, as well as this new Japan DAO LLC framework. And at Borderless, we're actually trying to build a platform to enable, well, initially targeting Japan to enable like a group to start a legal framework at an early stage to basically reduce the friction of operating the company, including fundraising. And in this case, it's more like digitizing the members of the LLC, where they all can buy these equity tokens in a legally compliant way. So a little bit, maybe it's not quite a DAO in the true sense, but it does enable, we're hoping it'll enable groups to more easily fundraise and then operate, governance and so on, their companies, than doing it the traditional way. And so right now, unfortunately, the members of the DAO, which are buying the equity tokens, all have to be living in Japan with Japanese addresses. So it's not as, it's not a fit for all great international groups. But that may change in the future, and I encourage anybody interested to maybe check it out. Again, I'll share an English blog post that has a little bit more info about that. But anyway, we had such great panelists today. I think they shared a lot of very valuable insights. Hopefully you guys all learned something. So please, thank you again for your attention, and let's give a round of applause to the panelists.
Thank you very much.
Thank you.
Arigatou gozaimasu.